As much as you'll need to know how your state's child support guidelines work and the different ways of calculating them and how the factors that go into the computer program or the handwritten analysis that you're doing of child support, how each factor might impact the support numbers in different ways. You also need to be cognizant of what they call child support add-ons, things that as parents get wealthier, they add on to what children do. So as much as the child support may take care of the nuts and bolts of day-to-day life, you also have work-related child care, health insurance, which is another thing you're going to need to know something about, the deductibles, co-pays, health insurance co-pays toward the premiums, the different pitfalls of having it reimbursed to the parents, different methods for making sure that the reimbursements get done and that there's good record keeping on that. Also things like lessons in soccer and the different things that parents who have more money do add on for their children. And so you want to take all of that stuff into account when you're drafting your judgment so that you do make sure that the parents have a meeting of the minds and also that your judgment covers the things that you know are important to your client. You know, these add-on expenses can be real enrichment for children, but as budget constraints get tighter, you really want to make sure that your client and the spouse are on the same page with this stuff and what will or will not be cut. You're going to save people a lot of aggravation up front by making the judgment more detailed on things like that. You'll need to know what your spousal support, spousal maintenance, or alimony laws are in your state, how easy or hard it is to get spousal support, and also what the factors are that influence that. But you'll also want to break it down a lot more specifically with regard to the different things that it can influence that. In some states, it's very difficult to get any kind of spousal support or maintenance unless you're disabled. In other states, it's much easier. But clients may want to do something a lot more specific than just yes or no and a flat line amount. They may be looking at doing a step up or a step down. Let's say you've got a situation where you've got a mom or a dad who needs to finish a teaching credential, and then if you can find the tuition money to have that happen and maybe a little bit more spousal support or child support or a different division of the assets in order to let that person, say, spend that last year or 2 years to finish the degree, they're going to need a lot less help later on, and so it ultimately is a good investment. And so you have to look at not only what the bright line of the law is, but what also makes sense in terms of negotiating and discussing your judgment and then ultimately pinning down the details. For custody cases, you need to know what the tenor of your jurisdiction is in terms of allowing people to move away, what kind of factors they're looking at in terms of best interest, what the hot best interest factors are. The child support or the child custody topics tend to come and go. For a while they were calling it the blanket wars, which is basically infant overnights. As the psychological research gets to be more specific with this, we get more information about what does or does not make sense. And as much as you want to encourage clients to be open about spending time with the kids, spending time with the other parent, you also have to make sure that, assuming that that makes sense, that the other parent is not some sort of a bad influence or a problem, that sort of thing, that what is going on with the kids is going to be in their best interest too, because the worst case scenario is that as much as the statistics and the psychological research may predict that it's fine for an infant to spend an overnight with a parent who hasn't been the person who's been responsible for most of the primary care, you don't want an individual child to be a guinea pig because it's much easier to start slowly and to build up rather than to throw a child into a situation where maybe they don't have the necessary attachment with a parent to spend the night and then it goes poorly, then you're really trying to make up for lost time. So as much as child custody is a best interest standard in most jurisdictions, and as much as there may be factors that the court looks at, you as the family law attorney also has to know about child development and child psychology so that you're able to help draft a developmentally sound parenting plan, which is something we'll talk about in another seminar. So if you aren't already overwhelmed by how much it's going to take to be a good family lawyer, There's even more topics, credit reports, joint credit, closing joint credit cards, the difference between having your name, on a credit card as a user versus a joint account holder, what happens when people don't pay, how it impacts credit. Clients generally don't know much about this. I think that's probably how people get into trouble. And the importance of even taking care of some of these little details. These are things that clients need your help with, in addition to things like basic court procedure and exactly what the laws provide for. As much as you want your client's agreement to be legally sound, you also want it to be financially sound and financially responsible. As a result, you're going to need to know something about basic financial planning and what some of the red flags are, and we'll talk about those in a little bit. This is a good time to get a good relationship going with some financial planners and accountants who will also be able to help your client out. There's a lot of different places where you can go to gain this knowledge if this is not something that you've got from your own life experience. The Los Angeles Times has some great articles in their business and real estate sections, and your local newspaper may or may not be as good as that. The Internal Revenue Service has some publications for divorced and separated individuals that are actually great, and you can download them off of irs.gov. There's this author, David Bach, who does a lot of financial planning books that really does a nice job of putting basic financial planning and saving and credit and this sort of thing into layperson's terms. There's other resources that you'll want to know about, for example, with a company called Pension Appraisers, which is pensionappraisers.com, which is where we outsource all of our qualified domestic relations orders to, and we also have them do our pension valuations. If you don't want to hire somebody privately, that can be an efficient way of doing it. I like my book, Your Divorce Advisor. Hopefully I'm not teaching experienced family law practitioners much, but it is a nice primer on basic court procedure, what clients and lawyers can expect as you go through the process. Every state has a book about family law. Here in California, it's the CEB Family Law Annual Volume, and also there's a Rutter Group Family Practice Guide. In Connecticut, there was an equally good set of books, which was a great, pretty inexpensive, all law books are pretty expensive, but a pretty inexpensive addition to your library if you didn't want to buy a LexisNexis subscription. So there's generally, in every jurisdiction, one or two books that you really ought to own. And then Certified Divorce Financial Planners is a new financial planning designation, Certified Divorce Financial Analyst, and those folks can be a great resource. We use them here in our mediation practice as independent contractors who come in and help people understand what their settlement is likely to look like in 5, 10, 20, 30 years. In a mediation context, we're doing that with both clients at the same time. It's a great referral source, though, for your clients on an individual basis as well, so that they get an idea of not only is a settlement 50-50 or quote-unquote fair or what the law would provide, but also what it is they're looking at, because you want the mix of assets that end up in this judgment to be something that meets their long-term and short-term needs.